So hello everyone, myself Advocate Gautam Harshwal, working at LEXIS and Company law firm as a junior associate. Today in this video I am going to discuss with you another legal topic, but the topic is of the same in the previous video, as we have discussed the meaning of double jeopardy and its constitutional values. So this is the second part of that first video. In this video I am going to discuss with you not the introductory part, because we already discussed in the first part. In this video I am going to discuss with you what parliamentary debates said on this topic, how it went away, and some other things all related to double jeopardy, right? So let's start our discussion without any further delay. Debating the issue of double jeopardy is an important basically content in Indian legal system and Indian judiciary. The content basically the content of double jeopardy has been a source of controversy and debate. How it was source of controversy and debate, because with the proponent arguing that it's an essential protection against government abuse, while opponents argue that it can allow guilty parties to go unpunished. How those in favor of double jeopardy argue that it's fundamental protection against government overreach. They believe that basically they believe that the government should not have the power to continuously make individuals for the same crime, as this would lead to an illegal and abusive legal system, right? Sympathizers of double jeopardy, or the people who were in its favor, said that double jeopardy also argued that the principle encourages finally in legal system, meaning that once an existent has been acquitted of a crime, they cannot be subject to further legal proceedings for the same offence. And on the other hand, opponents of double jeopardy argue that basically they argued that it allowed guilty parties to go unpunished. For example, they gave the example that if new evidence emerges after a trial, it may not be possible to try the accused again for the same crime. Indeed, if the evidence proves their guilt, right? They argue that this undermines the capability of the legal system to bring justice to victim and may lead to a sense of immunity among culprits. Another argument also given by against double jeopardy was that it may not be applied. It may not apply in cases where a mistrial occurs. How a mistrial is when a trial is terminated before a final verdict is reached due to a procedural error or other circumstances. In similar cases, some argue that the existent should be subject to a new trial, ensure to justice is being served, right? So let's next. That's all about the parliamentary debates. Now I am going to discuss how constitutional values what says about double jeopardy and CRPC in India, right? So the Indian Constitution is supreme law of land, and we all know that the Indian Constitution is the supreme of all. There is no one above Constitution in India, and because it is the supreme law of the land, and is the foundation. It is also basically the foundation of Indian legal system. It's living document. It is a living document that reflects the values and aspirations of the Indian people. And another thing about Constitution is that Constitution provides for a popular and temporal form of government, and lays down the abjuration rights and duties of Indian citizens. It also establishes the power and functions of the three branches of government: the council, the superintendent, and the bar. The Indian Constitution is grounded on the principles of justice, liberty, equality, and fraternity. These principles are elevated in the principles in the preamble to the Constitution, which basically reads that we the people of India. This is the preamble of Constitution of India. Many of you heard that. If not, I am going to read for you. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic, republic, and to secure all its citizens justice, social, economic and political liberty, to liberty of thoughts, expression, belief, faith and worship, equality of status and of opportunity, to promote among them all fraternity, assuring the dignity of the individual and the unity of integrity of the nation. Right, that's all about the preamble of India, preamble of the Constitution of India. And the doctrine of double jeopardy in the context of the Indian legal system is elevated in the Article 20 clause 2 of the Indian Constitution and section 300 of Code of Criminal Procedure, which is CRPC. It basically means that no person can be fulfilled or penalized for the same offence more than formally, right? And according to section 300 of CRPC, a person who has been tried and convicted or acquitted of an offence cannot be tried again for the same offence. It clearly says that in the CRPC, which plays a huge role in Indian judiciary. Basically, it is the core, basically the core area of Indian judiciary. CRPC, IPC, Evidence Act. If you are a law student, you might heard that. And still there are certain exceptions of this rule as well. What are the exceptions? Let's discuss. So the exceptions say that he or she can be retried if new and conclusive substances it is set up. If a person has been acquitted of an offence, he or she can be retried for the higher offence. If a person has been condemned of a lower offence and a higher offence is literally discovered, he or she can be tried again for the same offence in a higher court of appeal. If a person has been condemned by a court of competent jurisdiction. So that's all about its exceptions of double jeopardy. That's all about the second part of this video. I hope you understood. If you have any question, any query regarding that, let me know in the comment section. But before that, don't forget to hit that like button and share with your close ones. See you in the next video. Bye bye.